testifying on her own behalf. Brilliant con artist, charming the jury like she did her investors. Or an entrepreneur, a former CEO whose first stab at starting her own company at a very young age after dropping out of college, it failed. And she's just telling her story about having an idea and believing in a concept and being utterly determined to see it through, no matter what. One of the things we come back to again and again in this case is intent. And it's key in this case. It has to be proven intent, that she intended to commit fraud, to defraud investors. But before the court took a break, just before the holiday, Ms. Holmes' legal team showed at least more than one email from scientists and lab directors to Elizabeth Holmes stating the capabilities of the technology. Part of her defense all along has been that she's not the expert. She's not a scientist. Again, she's a college dropout. And she's not an expert, and she's relying on experts to inform her. So earlier on in the trial, when Constance Cullen from Sharing Plow testified for the prosecution, she said that when she was trying to work with Theranos, inquiring about the technology, she said she could never get a clear answer. Elizabeth Holmes was cagey. She tried to redirect the conversation, move to different discussions. This seems to be an attempt on the part of the prosecution to show that this is clearly because Elizabeth Holmes was lying. But isn't this also how someone behaves who doesn't know what they're talking about, doesn't have the facts or the numbers or know how to come up with all that information just as well? So part of her defense is again, relying on these experts, not being the expert herself. How does not understanding the technology suggest that she lacked intent from a legal perspective?
Right. So again, intent is basically that resolve or determination that the defendant had to commit the crime. And here we're talking about fraud, wire fraud. So does her knowledge, depth of knowledge of the underlying technology affect her ability to intend to commit wire fraud against investors, to commit wire fraud against doctors, to commit wire fraud against patients, which, by the way, those jury instructions are quite the contention right now between the prosecutors and the defense team. They're arguing it in court. So here, her lack of detail knowledge potentially underlying the technology, I believe, benefits her because she's relying on other people who are telling her that the device can do all these different things, that it can do 80 different tests, 85 different tests, 60 different tests, 1,000 different tests.
So far, the defense has delivered on showing creepy messages to Elizabeth Holmes from Sunny Balwani, showing him to be, at a minimum, very controlling, very particular, her feeling the need to ask permission to hang out with her friends alone, him having this list of, quote, non-negotiables that really sound almost like cult leader. Not that he is, but just weird, very controlling vibes. So still, her attorney asked her if Balwani, her Elizabeth Holmes attorney, asked her if Sunny Balwani at any time had forced her to say things to investors that were not true. And she said no. So she's admitting there that everything that she said to the investors, she said on her own accord because she wanted to, even though a large part of this defense is that she was being controlled by Sunny Balwani. So did her attorney ask this question to demonstrate that if she lied to investors, it was not knowingly, or if she was misinforming them, she was misinforming them. She was not lying to them. Because if she knew that she was lying, even if she felt that she was being forced to do it, would that not be very, very difficult to prove that you were forced to lie? It's one thing to be controlled and manipulated, and forced to lie seems harder to prove.
Yeah, that's actually why I've argued this whole Balwani made me do it, or Balwani controlled me, or Balwani abused me, or I don't believe that that's the defense that exonerates, or let me rephrase, that leads a jury to find Elizabeth Holmes not guilty. She is going to be found potentially not guilty because the burden of proof that she had the intent to deceive and knowingly intended to deceive. Remember, what the mistake that a lot of commenters make in this trial is they see one bit of information. For example, the Pfizer logo. That is a problem. That is not good for the defense. You're not convicting somebody of wire fraud over a logo, use of a logo. That's just not how this works. It's the totality of the circumstances. Did she lead investors down a path that was so fraught with misinformation, that was material misinformation, that led them to hand over their money that they would have not done otherwise? Same with the doctors. Did she lie? Did she knowingly give false information with the purpose of getting them to order more tests and refer more business to Theranos? Same thing with the patients. Did she communicate information via wire, meaning electronic communication? This is not in person. She is not accused of fraud. She's accused of wire fraud. So that has to do with electronic communications. This is a big deal. Single instances of misrepresentations are not what convict people in a fraud case like this. It is the intent. It's knowing this is totally false. It's material to somebody making a decision, and it's causing them to act and hand over their money. And we've been through the elements of fraud many times, and I've put the link out for the model jury instructions. So when I hear things like, well, Balwani didn't make me say these things to the investors, great. So she knew what she was doing, and that weakens their defense that blame Balwani for this. It's on Elizabeth Holmes. Her actions are on her now. And again, the burden is on the prosecution. And you can hate Elizabeth Holmes, but they have to do this for the jury to come to the conclusion that beyond a reasonable doubt, remember, that's a very high standard in a criminal trial. Beyond a reasonable doubt. That's you'll hear lawyers, nobody ever likes to put a hard number around this, but it's, high level of certainty, meaning like 95%, 98% certain. There's no hard and fast number on that. But that she didn't just make mistakes, that she intended to deceive so she could take their money and did it in an electronic communication. I just think that this line of defense is not one that damages Elizabeth Holmes. If anything, if I'm Sonny Balwani and I heard that, and I'm his defense team, I think, I'm going to make sure I'm using that at my trial coming up.
You mentioned much earlier on, one of the earlier episodes about Elizabeth Holmes, that Sonny Balwani would not be called to the stand, would not be subpoenaed, because he would automatically take the fifth. And when all of these texts and all this information started coming out with Sonny Balwani's name on it over the last couple of weeks, one of his attorneys made the statement, Sonny Balwani will absolutely plead the fifth if he is called to the stand. So you're not going to get anything from him. But would there ever be any point to call someone like Sonny Balwani in this case to the stand anyway, knowing that he's going to plead the fifth, just to ask the uncomfortable questions, put the questions out there, and even just rely on the jury to some extent to read body language or note his response or his reactions or the way that he pleads the fifth.
Well, I mean, I'm sure that there is a circumstance where you would do that, but the judge maybe will have issues with it as well. And that can cause issues.
Does that mean on the stand, the judge would not allow an attorney to continue questioning a witness who just keeps pleading the fifth? They just wouldn't allow that?
If the judge determined that would be prejudicial for the jury to hear this and it lacked probative value, yeah, the judge can do that. But I would add, in this case, the prosecution definitely wouldn't want to put Balwani on the stand. Well, that's my take on it, because him endlessly pleading the fifth, if it's going to do what you're describing there, that's actually going to make people think, well, Balwani's the guilty one. And the defense maybe would want to put Balwani on the stand if they're trying to blame Balwani, but we just heard that line where Elizabeth Holmes said, no, he didn't make me say things to investors. So if that's the case, there's no point putting Balwani up there just to say, making his statement about pleading the fifth in response to every question. In political theater, if it was something like that, you'll see people want to hear people plead the fifth. In a criminal trial like this, it's not going to further, I believe, either side's interests. And that's probably why they didn't.
Holmes admitted on the stand, as you mentioned earlier, that she inappropriately used the Pfizer, among other professional logos, without permission. And, almost sometimes when someone admits to a little lie, it can build trust, even if they're hiding a lot more. And I'm not saying she is or she isn't, but sometimes that can be used to make someone feel like, if you would admit that, then if you were doing anything else wrong, you'd probably admit that too. So you must only be guilty of that one little thing that you admitted, or that might be kind of, that sometimes has that effect. So the thing is, she admitted to that, and whether she planned to say this or not, it seemed to me, and again, the disappointment that I don't get to see this myself on camera is huge. Reading this is not the same. But she threw in this line after she made the comment that she wished she had done that differently. Sorry that she used those logos. She wished she had done that differently. Then she threw in this line, I wish I'd done a lot of things differently. If you're her attorney, do you cringe a little bit at that? And could that be taken as an admission of guilt beyond just the logo?
If I was her defense attorney, I would cringe, because now I have to come up with an explanation. I have to justify what she said. But that's an easily justifiable line. And that is, look at all the people who've stabbed her in the back. I mean, this is how I would present it. Now, again, you can disagree with this, but if I'm the defense attorney and I'm presenting this to the jury in my summation, I would say, look, if that came up, if the prosecution brought that up in their summation, I would counter it by stating, look, a lot of bad people. She made bad hires. She clearly wishes she hadn't gotten involved in a romantic relationship with Sunny Balwani. Look how horrible that was. Don't you have things in life that you regret that you would have done differently? Absolutely. We all do that. And anybody who's built a multi-billion-dollar company, at least in terms of valuation, and then have it implode, clearly will have things they wish they would have done differently. So in this case, it indicates nothing regarding guilt. It indicates that she wishes she had made other decisions when building this company so it could have sustained a level of success and we wouldn't be sitting here today. That's how I would be spinning that as the defense attorney. Obviously, the prosecution, I would pick on that and say, there, she just admitted it, folks. She just admitted it. In so many words, she just said she wished she would have done a lot of things differently. And she said that in the context of something that is fundamentally and materially wrong, and that is the use of Pfizer and shearing plow logos on their materials without permission. She knew she shouldn't have done that at the time. She did it anyway. That leads you, members of the jury, that what we have presented in terms of evidence that she knew what she did was wrong, that is part of the pattern of her conduct. So these are the arguments that would be made. But as a defense attorney, I don't want to hear it. I have an easy answer for it.
Thank you for listening to Law Junkie Show. Please subscribe to us on Apple Podcasts and on YouTube. Leave us a review on Apple Podcasts if you like this show. And contact us at info@lawjunkieshow.com. Go to lawjunkieshow.com and fill out the contact form there.
Disclaimer. Law Junkie Show, including its guests and hosts, are not giving out legal advice, but discussing general legal issues. Law Junkie Show does not guarantee that the legal issues discussed are fully accurate, and it's not specific to whatever legal issues you may be experiencing. None of this advice is to be acted upon in your situation. Please seek legal advice from a licensed attorney in your jurisdiction for your individual legal matter.